This meeting to order. This is the Charter Review Committee, Tuesday, January 19th, 2021. If I could ask you all to stand for the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Madam Clerk, will you do the roll call, please?
Yes. Grace Reed. Here. Michael Goodfellow.
Here. I can't hear.
Can't hear.
I'm here.
Linda Kitchen is excused tonight. Sherry Matthews.
Here.
Larry Napier.
Here.
Karen Jordan. Here. Beth Mitchell.
Present.
Louise Cottenberg.
Here.
Sharon Herman.
Here.
Patty Sullivan. Here. Dave Newhart.
Here.
Amber Serta. Bruce Hoffman.
Here.
John Christino.
Here.
And Vicki Drumheller.
Here.
Thank you.
Thank you. So welcome everybody to our first real meeting for the Charter Review Committee. The next item on the agenda is approval of the minutes.
Move approval.
Second. I have a motion and a second. Any discussion? All in favor say aye.
Aye.
And all opposed? Like sign, motion passes. Thank you. Item 5 is a review of public input rules, and I would like to just make a few housekeeping comments. In approaching this committee's work, I would like to ask that we kind of keep it somewhat informal, a little bit more like a workshop approach instead of a formal council meeting. There has been a schedule of meetings for us provided, and further in our schedule is a date where we will go back and review each item that we think needs to be changed. So while we're talking tonight and as we take a vote, I would ask that you at least consider whatever the item is and don't definitively make up your mind, because we will be coming back to it further on down the road. The vote tonight on any item would be to put it on a list. And Madam Clerk, are we working the overheads that we talked about? Oh, okay. All right. So as an item comes up, we have the ability to put it on the screen and keep a running list of what we're talking about. So I think that will be helpful to all of us. The other item that I would like to mention is the review of public input rules. And I would like to suggest that this committee modify the council's rules in terms of public input, and instead of allowing 5 minutes, that we keep it limited to 3. Whoever is speaking to us from the public will be addressing specifically the issues that are in front of us. So I personally believe that the 3 minutes would be sufficient to take public input. Does anybody have any issue with that or concern?
I do. You know, it's easy to go over 3 minutes. You'd have to ask permission. I believe the council just voted on this. They had this at a meeting last month, was it? And they voted to keep the 5 minutes.
So are you saying you would prefer the 5 minutes?
I prefer we stay at 5 minutes. Some people aren't that well-spoken, and they can't necessarily get their idea out as quickly as others. 3 minutes goes quick by the time you give the name, your address, and so on. And I know that's an issue. We had that with the annexation. A lot of people had a 5-minute prepared speech. Couldn't read half of what they had. So I prefer that we stay at 5. I don't see it being an issue. We've had some input now with the masks. We have, a particular group, which I don't anticipate staying on for 10 years here. but I prefer we stay with the 5 minutes. It's
I agree.
necessary.
Does anybody?
agree.
You agree with that
I
too?
agree.
All right, well, let's just see a show of hands then. Who wants to keep it at 5 minutes? Okay. That pretty much looks like more than half of the group, so we'll keep it that way. So at this time, we're going to start talking about the first section of our charter, Section 1. It covers 4 areas: extraterritorial powers, intergovernmental relations, boundaries, and existing businesses that may continue after annexation. Before we start discussion, I will open it up for public comment at this point. Is there anybody on Zoom?
There's no one with their hand raised on Zoom.
Okay, thank you. And we have no public in front of us, so I guess there's no public comment. So, out of the 4 items that are in front of us, does anybody want to speak to any of those first 4 items in Section 1?
I think they're fine as written.
Anybody else?
I agree with Larry. You have a little duplicitous language between 1 and 2 concerning the seawalls, yacht harbors, wharves, warehouses, where it's repeated again in 2, but it's not even a full sentence, so I see no reason to alter it at this time.
All right. I had a comment on, let me see here, paragraph 6, which is at the top of page 4, and it addresses stock. And it says, to provide for inspecting and regulating the sanitary condition of all butcher pens, meat markets, or other places within or without the city limits, for the products of the same are sold within the city limits, and to provide penalties for the violation of such regulations. I guess I would ask the city manager if he could think of any circumstances where that paragraph might apply.
There could be, in some of our industrial uses where you could have slaughterhouses. We really don't have an agricultural zoning district within the city currently, but we do have the chicken rule in our ordinance, but this particular item deals with agricultural stockyards and that, which could come to play if property was annexed in. There could be an opportunity for a stockyard or a butcher shop, but they're also regulated by the state. So it's a catch and a cover, but that's it to the group on how they want to manage that. If that answers your question.
It does. Thank you.
I've got a question on that. I know that the county does the health inspections for like the supermarkets, the meat departments, and that sort of thing, correct?
Well, those are
So our city doesn't really oversee that. If we had a meat market opened up in town, a butcher, would that pertain? Or would that fall under county regulations, Paul?
So it's a multifolded question. So it would fall under the city's ordinances and guidelines to make sure that the processes and the humane slaughter of animals and things of that nature were adhered to. They're licensed through FDACS, Florida Department of Agriculture and Consumer Services, and through the state, so other state agencies. It would give us the limited ability to regulate the humane slaughter of animals, the discharge of the waste products from that into a septic or sewer system that's adequate to support that type of construction or type of market. So there are, in sanitary conditions, air quality, the smell that comes off of there, how would you regulate that? So there's some opportunity for us to have some regulatory beyond what the state does.
I agree.
Beth,
Yeah,
under paragraph 4, it
yes.
may or may not be appropriate, but I would like to see Wi-Fi added, and I know it's,
Okay.
Yeah, I would support what Louise is, 5 years ago, we had this discussion about whether to add the internet, and now Wi-Fi's become a big, I don't know whether, I mean, obviously, I would think maybe it should be in there. I would support what she's talking about. I don't know how we would specifically add it, internet, Wi-Fi, or something to that effect, but we had this, I remember the discussion from 5 years ago.
I just think it would be a public
We
service.
didn't really do anything with it. We thought it was just, at that time, maybe too immaterial, but it obviously is not immaterial anymore.
Is that something that the rest of you, we could at least put on the list to consider?
Yes.
I would say
Let
to
me
put
see
on
a
the
show of
list,
hands for
yeah.
the Wi-Fi. Okay.
Yeah.
All right, we have our first item. Got it?
Could I make a brief suggestion? I know I'm not supposed to, but
No,
I
go
thought
right ahead.
maybe you should, because this is a document that's gonna be around for a while, and I'll ask the attorney, but I would say to furnish all local public services, including, but not limited to, electric, gas, communications, not just Wi-Fi communications, so that you have a catch-all. You don't have a requirement to, but you're not limited to. So it's an example of, but my only suggestion.
I agree with that.
Yes.
I would agree with that. I just thought that, you know, that might limit it if we just say Wi-Fi, because there are other things coming out, other than just Wi-Fi. So if we at least had that.
Yeah, I'm not even sure Wi-Fi is the correct terminology.
Right. There might be a couple of other terms that would kind of cover it, but also the not limited to, I think, is
Okay.
key.
Okay. All right, could you capture the comment about, but not limited to? Okay.
Yeah, that would go in the first line, right? Is that what you're Paul, is that what you're trying to say at the on
Yes,
the
sir,
top
where
of the
it
first-
says including-
Yeah, including, and
I would say,
then
but not
comma,
limited to.
but not limited to, comma.
Okay.
And I would add the term, my suggestion was to add the term communications. Limited, including but not limited to communications, comma, electricity, gas. That was my suggestion.
Larry, did you have a comment?
I think it's fine the way it's written. I think it's covered.
Okay. Okay. Is there any other input on section 1? I know you all are eager to get to section 2.
Yeah, could I just ask if the attorney could comment on nuisances? Do we need, is that covering in item number 5? Where it discusses, are those only public nuisances, or are they, or is that considered public and private?
It says all. I don't know.
Yeah, it says all, but what does all mean? Does it mean all public, or all, or both public and private nuisances?
Okay. All questions to the chair. So through the chair,
Okay,
I read it the same way, meaning all nuisances. I don't know the history of this statute or this charter provision, but to me, all nuisances include all.
Are you good with that, Bruce?
okay. And then on item number 7, under the airports, do we need to add or discuss adding something about drones? There's no mention of drones.
Well, how would you?
Or is that covered, or do we just defer to the federal government and the FAA for that kind of regulation?
The FAA regulates drones. I don't believe we could if we wanted to. We could probably pass some kind of a rule.
And I'm not sure that we would put a regulation into the charter at this point. I think you could do that by ordinance.
Okay.
Okay. Anything else on section 1? Okay. We will go to section 2, and I think that this is where our real work will happen tonight. So before we get started, it does have 16 different paragraphs. I'm not going to read them all, but before we start our discussion, I again would ask for public input. And if there is public input, I would ask that they are specific in which section they are giving us input on. I don't see any public here. Is there anybody on Zoom?
There is no one at this time.
I'm sorry?
There is no one at this time.
Okay. All right. Thank you. All right, so let's go to the first item is composition. Anybody have any comments on composition?
I do.
Yes?
And it's just a question to think about. I think we might think about, instead of a composition of 5 members, 7. And the reason I would suggest that is this past year has shown us that it might be a little bit too easy to overwhelm the council with just 5 members. It might be more difficult to have an overwhelming voting bloc, as it were, if the council were a little bit larger. And we also have a significantly larger population than we did when this was originally drafted. I don't think that 7 would be out of line. I know many cities of this size have as many as 11 members. And that's just a comment for thought.
Dave, did you have a question? I thought I saw it.
I would just ask, as a point of order and point of courtesy, that when somebody speaks out, that they at least don't just jump in and jump over somebody, because there are people who would like to speak, but however, when somebody jumps ahead, I'm courteous, I'll raise my hand. I would just ask for that same courtesy.
Okay. All right. Yes.
I have one question about the 5 to 7. Is there any ordinance that requires a compulsory vote for the entire council to be in agreement?
And you mean like a unanimous?
Yeah, if there, that would be one of the things to think about with extending council number, is it may be much more difficult in situations to get unanimous consent.
I don't know the answer to that question. Mr. City Attorney?
There's a couple of things that might require unanimous, like when you're doing the, when you're before council and they want to make any amendments or any changes to the agenda requires a majority. But anything substantive, I don't know of anything right now. And I don't know. I mean, it usually requires a vote of majority, which will be, in this case, 3. And that's what the charter says. 3.
Mr. Carlisle?
There are cases in statute where if a certain millage rate is to be raised, it would take a unanimous or a supermajority in some cases, or a unanimous, depending on what millage rate you're going to set, if it's an increased millage. If you're going to set up an MSTU, MSBU, and there's a millage rate set up with that, it takes a unanimous or a supermajority vote. So there are instances, though the city hasn't experienced those at this time, but there also are maybe instances that would have to be thought about, is what regulations do we have in place that would all need to be changed, where it's a 3-2, where it specifically says a 3-2 vote versus a simple majority?
I forgot to mention also the charter requires majority vote when you have these emergency ordinances.
I saw that, yeah. Yeah.
Louise, you mentioned population change between prior, and
and now to increase that from 5 to 7. Does anyone know those numbers? I know with some of the new house things that are being built, there will be an increase for Sebastian. But I haven't been here long enough to know what 5 years ago or whenever this particular rule was made. I understand what you're saying, and it makes sense to increase it as the population increases, but has that happened? And is it a ratio that we look for? How was it determined initially as 5? 3, 5 and not 7?
This is my third time around, so I can't talk about anything that happened longer than, and I think the first one's 15 years. I can't think of anything, I can't speak to anything that happened more than 20 years ago. Okay? It's been exactly the same for 20 years. And when my first recollection of the population at that time was less than 10,000. So we are more than double that now. And I just picked that number from the air,
Thank you.
thinking of it for discussion purposes.
Yep. Go.
I understand your point. I think, I know with the county commission, I know they have 5, members. I'm not sure about Vero. And I guess I would just caution that to rectify this one particular situation, I'd have to see a little more substantive, reasons as to why we would want to change it, other than the debacle that took place with this, because it did resolve itself, through the citizens. And so if that would be the only reason, is to protect a future, situation, I think I'd have to see a little more than that, because I think we did, resolve it, and I'm open to listening to it. I'd have to see very clear reasons as to why it's important, imperative that we change it. So I'd have to have something very substantive for that.
Larry?
The number of council members is not predicated on population, and in the city of Sebastian, the council members run at large. It's not even, they don't even have an area, so it wouldn't matter how many people you had. 5, I think, is enough for the area that we have. And you can only cram so many people in this area because of the housing regulations and things, so I think 5 is an adequate number.
Okay. Dave?
I would agree 5 is probably adequate. I mean, even if we take a look at the population of Indian River County in general and how much it's grown, there are still only 5, county commissioners that are serving an enlarged population and needs of this whole county itself. I think when you run for city office, you understand that there will be some additional charter or committees that you need to be, that you will be assigned to and responsible to. And that means that ahead of running, just rather than just having a seat up there on the throne, you are at the point of, I understand that, and I am willing to invest my time and my efforts into those different committees. So I think 5 is good. Trying to find a supermajority in 7 or a unanimous in 7, that creates a lot of tension and dissension.
John?
I'm going to follow up and agree with Dave Newhart. I think 5 is fine, and we could open a can of worms with 7. Getting 5 to agree at times can be challenging. 7 could turn into additional hours on meetings with the banter back and forth. On a side note, I understand where Louise is coming from, trying to prevent a takeover by any 3 individuals, but I think the citizens of the city learned a valuable lesson last year, and we'll be extra careful to not repeat that mistake.
Okay. All right. Anybody else have any input on that? All right, let's just do a show of hands. Who would like to see the composition increased to 7? Just you. Thank you, Louise. I'm sorry?
Goodfellow raised his hand. I know you can't see him right now, but he did raise his hand.
Who? Where is he?
He's on Zoom.
When did he arrive on Zoom? Okay, I thought I asked if there was anybody on Zoom. Okay, all right, so Mike, are you on Zoom? Does he want to make a comment?
I was just signaling my approval. You asked for hands to...
There he is.
Hey, Mike.
All right, Mike. Okay, so I think we'll just move. Mike, do you have anything you want to say on composition of council? Okay. All right, we'll move on to intergovernmental relations. Oh, I'm sorry, scratch that. Eligibility. Section 2. You threw me off, guys. Eligibility.
Beth,
Bruce?
question, at the end of the first line, where is a qualified elector defined? Where are the is it defined somewhere else in the charter?
Mr. City Attorney.
No, but any questions to qualifications, I'll defer to the city clerk.
It is not defined, but as candidates come, they sign an oath saying that they are qualified to run for office, meaning they don't hold another office. And we require a form that they have lived in Sebastian 1 year prior to the closing of qualifying. So there are some qualifications, but obviously, me and the city attorney talked earlier, you have to have your civil rights, so, to run for office. So,
You can't be a felon.
I didn't hear that. What was
Yeah, you can't.
you do have to have your civil rights to run for office, but it is not defined in statutes.
I have a question for the city attorney that might help this, Bruce. There are qualifications on a state level for candidates. Would they apply?
Barring anything in our charter, no, it will apply. Our charter will have more presence, but we cannot make, strike that, we cannot make changes that are inconsistent with state law at this point in time. But I am not sure what qualifications, other than what the clerk was talking about right now, are for elected officials. So, I mean, this is an important section, but, I mean, right now, what we have to define eligibility is the residency, and that they, I think it's just a 1-year residency,
And that they hold no other office.
Say again?
And they hold no other office.
That's in the form that they fill out,
Yeah.
correct?
Mhm.
And the form that they have to fill out, which is separately.
Bruce, do you have any more comments on eligibility?
I do. Somebody.
Okay, anybody. Sharon?
Okay, I've got a couple of questions.
And I'd ask you to speak into the mic.
Oh.
I don't know about anybody else, but I'm having some difficulty hearing.
I'm sorry. I've got a few questions, and again, I'm the newbie, so.
That's okay.
But with that being said, on the eligibility, is there anything that is specified anywhere that makes a candidate ineligible? As far as, and I don't even know if we can broach this, but felony convictions, misdemeanor convictions related to fraud, theft, tax evasion, embezzlement, things that could have a direct effect on their voting and their judgment for municipal issues. And also, is there any way to make a candidate ineligible if they have been previously removed from the city council office or a city commission, or a city committee? can that make them ineligible to run again
If they have been removed?
if they have been removed?
We don't have anything in here now. Is that something you are suggesting?
Is it legally possible to do that? I mean, like, I know we can't go against state statute, but can city requirements be stricter than state, but not less strict than state? Is that?
Okay. Through the
I
chair.
know.
Yes, Ms. Herman did ask me a couple questions, but I was hoping that she would ask it here during the committee, go through the chair, and I'll go through the chair. The questions that were asked is whether or not, I don't think it applies to misdemeanors, and I don't really see how we could restrict someone for a misdemeanor, but when it comes to convicted felon, like the clerk was alluding to earlier when Mr. Hoffman asked the question, is you really have to have your civil rights restored. Amendment 4 did not, all Amendment 4 did was give convicted felons, some of them, not all of them, those that were for lesser degrees of felonies, the ability to vote, but it did not give them the authority to attend and be a part of juror selections, and did not also allow them to run for office. So the only other way, what she was saying is, the answer to the question, if someone is a convicted felon and they want to run, then the question would be, have their rights been, am I good? Oh, no, because he's looking at me. So have their rights been reinstated? That's the only other way, meaning either they gone before a clemency board or the governor's pardoned them. It's the only way that they can really run for office. The other question you asked is whether or not if they've been recalled, can they run? The statute itself, which is Florida Statute 100.361, subsection 8, specifically bans them for 2 years. So that answers your two questions.
But only 2 years?
Okay, Grace, I know you were ready to speak.
Yes, I wanted to kind of feed off of something that Sharon had said. And I really don't know the answer to this because I was looking into some of the things in the Constitution, and it didn't really say anything felony specific, but I saw in there something about being charged with either felony or misdemeanor or any crime that would violate public trust. And one thing that I was wondering is if you were charged and you go to court and everything and you file no contest or no contempt, whatever that is, I know if you're adjudicated guilty, you're guilty. If you're not guilty, you're not guilty. But if the adjudication is withheld and pending you going and doing some probation or whatever, is that still considered guilty? Or is that considered not guilty? Because in my opinion, if you have violated a law and you have just said, well, you've got enough on me, so I'm just going to lay myself and let you see what it is you're going to do to me, and they slap you on the hand and say, go pay a fine and do a little bit of probation or parole or whatever, to me, you still violated the public trust, and I don't think that you should be eligible to make decisions for the city.
I'm going to speak
Well,
up.
before I call on anybody, I think we need to ask
Yeah, I mean,
Mr.
just
Anand
to, so I know where I am here.
I heard a lot of comment. I didn't hear a specific question, so
I think
if
the
she wants to
question was
restate the question, I'd be more glad to try to answer it.
The question was, if you plead nolo contendere, is that a guilty or a not guilty dispensation of the case?
Adjudicated withheld.
Okay, if you would hold adjudication or you plead nolo contendere, then nolo contendere is not a conviction. So it's not a conviction, to answer your question. Now, I was looking at the statute really quick, because I know that 112.51, I don't want to restate, I want to look at it really quick. 112.51 is the statute where the governor can suspend people. And I thought that one specifically defined, even if you are nolo, or in this case nolo, it's still considered a conviction, but I have to be sure, look at the statute really quick. But the answer to your question, nolo contendere or withhold adjudication are not convictions.
And we had to look at this, and when Jim Stokes was here, and you're correct, for the purposes of removing someone, nolo contendere, no contest is considered a guilty plea for removal, but I don't know that it would be a condition for not being able to run. So the Constitution, when it talks about the things that you were looking at, I believe that section of the Constitution was also discussing the governor's ability to remove them from office, not necessarily running for office, if I'm thinking of the same article.
I believe it is.
Dave, I wanted to get back to you.
I think she raises, Sharon, you raise an excellent point, and I don't have my glasses on to see your name over there. But, when somebody goes for certain jobs or things like that, they always ask you, do you have a felony conviction? Or even when you go to rent a house, they ask you, have you had a felony conviction of any type? And based on that, then it would negate them from getting that job. I see that our government here, is we need to hold that higher standard. So as, our illustrious city attorney says, misdemeanors, not necessarily. However, if you do have a felony conviction, I would not want you in a position of power to lead over the city or something like that. I would like to explore expanding that portion of the, of what we're talking about right now in the eligibility. Granted that downstream, it's also if there's a vacancy and talks about moral turpitude and all that kind of stuff. But I think the foundation is, where are we? Who are the people that are running? Do you have convictions? And what, and as you alluded to, the public trust. I mean, we have to be, whoever runs for council or any of the commissions or committees here, you have to hold a higher standard so that you are representing the community at that level. And, but letting somebody slide through the cracks just to be there, that's a different story. So I would really encourage us to take a deeper look into, can we tighten that up for a certain degree?
Nikki? Go ahead.
One of the things I'd be interested in looking into, would a qualified elector be someone that had all of their obligations to the city paid in full, like the rest of us? And also, there is a document, I'm a registered nurse, and one of the things that we have to do is called an affidavit of good moral character. And it's in state statute, and it has multiple misdemeanors and felonies that would take you out of the running for a position of authority or trust. And I don't know if we have such a thing in the city, or if we even do fingerprinting for candidates. Is that something that is part of the process? I'm not sure that's a charter, that's more of a process than here.
Yeah.
But I think for the city to define what a qualified elector is probably more important than changing this sentence.
All right. Okay, good.
I'm in agreement with pretty much everything that I've heard. I would just caution that, where do we finally draw the line as far as, how far of a, how far down can we go on a certain thing like that, where we supersede our own constitution, and if we don't like certain things about certain people, we can say you're unqualified. So it would have to be a legal basis for those types of things, and also there would have to be a clear, definitive line as to, I have personal opinions about what I saw took place, with most recent things, and we did the right thing. But I also just want to make sure that we don't, there's a strict line in regard to the state constitution and to the federal constitution, where we have to draw certain lines. I'm certainly in agreement with the felony, so.
Bruce, go ahead.
Beth?
Well, instead of trying to change the charter, could the qualifications be done through a city ordinance?
Mr. Attorney?
The answer is yes, or a resolution.
That's a great point.
Can I follow up?
Sharon?
I think as far as like specifying the qualifications, but personally, I'd really like to see something that also specifies the ineligibility, not just what makes you qualified to do it, but something in there that says no.
All right, I saw a couple of hands over here. John, I'll start with you first.
A possible requirement for a background check. For whoever's running for city council.
Larry?
Since qualified elector, the attorney qualified elector is not defined in the statute, is it defined in case law or Attorney General's opinion? Or could you go to the Secretary of State and ask the opinion of what a qualified elector is? In my opinion, a qualified elector is someone eligible to vote in the jurisdiction, period. If you're not eligible to vote, you're not a qualified elector.
That's true.
And Dave, you had your hand up.
No, I was just pointing so John could talk.
Okay. All right. Has everybody had their say on this subject? Go ahead, Grace.
Yes, Madam Chair, I had one more question and just kind of an idea to throw out there. To me, the city council is the final decision maker. A lot of the decisions are from other boards and committees, and those things are presented to the council. So it looks to me like the majority of the work, if I'm correct, is done in your plan and zoning, in your natural resources, all of those boards and committees. What about a requirement that a candidate would have fulfilled at least one full term and at least one board or committee, which number one would give the Robert's Rules experience. It would give them more of an opportunity to say, this is, I feel passionate about this. This is what I want to see, where I want to see the city go. And I just feel like if someone had that type of experience before they went into running for city council, instead of just, a couple people asked me to do it, I think it would be more beneficial, and I think we'd have more experienced people. That's just my feeling. I don't know how anybody else feels.
Dave?
I would like to refer this through you to our city attorney, based on what Bruce had asked earlier, that it looks like we could say that these qualifications, we could put them through either an ordinance or a resolution to be the foundation of it. I was going to parrot what John said about, background checks. Even me as a priest, I had to have background checks, things like that, again, a position of trust. But I would agree that, there's things we can do to tighten up, as you said, Grace, to say you have to have some sort of experience with the city. But does it need to be right here in 2.02, or could it be in a resolution and therefore referred to for qualifications in resolution number, whatever it is? So my comment, and through you to the city attorney, is that possible?
Okay, the direct answer to the question is yes, it's possible. But let me backtrack. This is the charter, like I've explained to you guys last time. This is what's going to govern this is like our Bible. This is our Constitution. The purpose of the charter is, if you so choose, I hear a lot of people saying that qualified elector is not defined. It is kind of vague. However, when you read the whole thing, it is defined, but they only have one definition, and that is that you continually reside in the city for a period of 1 year immediately preceding the final date for qualification as a candidate. That makes you qualified. If you want to entertain additional comments, I'll be more than happy to suggest, because I've looked at other charters as well, but you can add it. I hear a lot about convictions. I hear a lot about the issue with the governor suspending them. those are things that you can add to the charter, or vice versa. If you don't want to add it to the charter, answer your question is, if the council so chooses, they could probably do it by ordinance. That would probably be by ordinance.
Vicki, and then John.
I would definitely like to kind of put this as a, let's come back to it for two purposes. If the qualified person only has to reside for a year, I really think we should consider not only a Florida FDLE background check, but if they have only been in the state for a year, that fingerprinting be done. Many professions have to do this regularly, over and over again. And I would like to know that the people on our council that are choosing how the city is going to go forward meets at least the minimum requirement of most professions that are licensed in the state of Florida.
John?
That may be possibly going a bit far, but we'll see how that goes. I think ultimately, in the end, after we have public forums, we have interviews with candidates, the public has an ample opportunity to look at the qualifications of each individual that is running for the city council and judge them accordingly, instead of setting up a class standard of you can't get into this class unless you've sat on planning and zoning, or you've been here, or you've been there. I believe that's up to the voters to make that determination, what qualifications they're looking for in a city council member.
Okay, thank you. Louise?
With respect to background checks, I do work with them.
Louise, could you speak into the mic, please?
I'm sorry. With regard to background checks, I do work with background checks from time to time. And I just would like to caution you to say that you must provide a background check is meaningless unless you have a standard that says, if this shows up on a background test, you're either eligible or ineligible. Because background checks can be very detailed, they can also be very minimal, but the important thing is you have to have the standard. Otherwise, it's meaningless. I agree.
I agree.
Okay.
I mean, and also, again, you're going to have very, very clear stipulations as to, you know, what line you're going to go up to as far as what, you know, you can have a lawsuit on your hands if something happens on that background check that's inaccurate or anything like that. So, again, I think it could be a slippery slope if we're not respectful of the voters. I mean, I've seen 18-year-olds run for city council and do a better job than some 45-year-olds. So I train teenagers for the political process, and some of them have ended up as state legislators at 23. So, you know, if they can learn the Roberts Rule of Order when they're teenagers. So I think I appreciate the felony issue. I think we would have to compare it to what other cities do, what other county legislatures do, and then also the Florida State Constitution and where they draw the line.
Okay. Dave?
I know we seem to be circling the wagons many times in this. We've got some really good ideas that are coming out, such as, you know, background checks, what it would be. I love Patty's idea of saying, you know, we have a minimum age in which they can run for Congress or Senate or whatever. Maybe that's something that we do, somebody coming in. But I would like to move this to a different discussion on a different day and come back to this, because otherwise we're just going to keep circling the wagons with ideas, and it's better to have a time of dedicated discussion about that rather than just circling the wagons.
Let me say this, Dave. I think that we need to make some determination whether or not this item is going to get to the list. This is our first swipe at it, okay? So I think that we need at least a consensus that we want to review this. And have you been taking notes on all of the different ideas that have come up? Okay, so I have. background check seems to be the biggest issue for eligibility. A felony conviction is another item. And I see a couple of hands up, so I don't want to, go ahead and,
Well, what Dave is saying is good. We don't want to go round and round, and what Patty said was good. What if I'd be willing to go to one city or two cities at the most, just to find out what they have, and then readdress it after we come back, because we still have some time. But I think knowing a baseline it doesn't sound like this has been addressed before here in Sebastian. Has it been addressed?
not that
To
I
your
recall,
knowledge?
Louise, have you? Larry?
I have a question. What are we trying to fix? I don't
Yeah.
see anything broken here.
Well,
I hear
Larry,
you.
I think it is broken.
Yeah.
It's not defined. If you read this, a 10-year-old can run for city council.
A 10-year-old can't be qualified to vote, Bruce.
Well, but it doesn't say you have to be qualified. You brought that
It
up.
says qualified
does.
elector.
It does say that.
What does that mean?
And that's where we get
Doesn't
back.
say qualified voter.
A 10-year-old can't run for city council. A 10-year-old
Why
can't
not?
run for public
It's not a
office.
voter.
I put that question through you,
He's-
Beth.
he's-
Asked him, why
So-
couldn't a 16-year-old run?
I
Okay.
think you have to be a legally registered voter.
Where does it say that?
It doesn't.
It doesn't.
Let me say this, we also could get really bogged down with this
Yeah.
long list of potential qualifications. I really liked your question to the city attorney about those qualifications being listed by resolution or ordinance as opposed to inserting it into the charter. That's kind of where I land on the issue. So in order to keep moving this forward, I'm going to agree with Dave. We've got some items up there. Age would be another item. Grace, you mentioned you wanted some experience
Yes.
with city matters. Yeah. Was there anything?
Registered voter.
A registered voter, okay. Dave?
And if I heard right, our city attorney said he would also look at other cities and how they qualify their council members. And if we
Did
could-
I?
if we
I'm not
could
sure
get
I heard that from our city attorney. Manny, did you?
No, I didn't. I didn't say that, but again, this is not city attorney lane, this is really a city clerk lane. So they're
Okay.
the one that has to qualify
Okay.
the candidate. So if anything, and I'm not saying that's what you need to do. I mean, these are the kind of stuff why we had a whole month to go over these things, is so that we can come today prepared to have discussions. To hold this off until next month, I think we're going to be pushing against what we got to do, which means get everything done within 6 months. So I caution the board now, it's very simple. If you want to make a definition, it is important to define what an elector is, just define it. I think background checks is going way into the weeds, though, me personally.
I
But,
would like to get these ideas up here, and then in the event we decide to hand this off to city council, they can see the different items that we are considering. They'll see that in our minutes. Paul, did you have?
Yeah, Madam Chair, if I may, just also keep in mind that what you're asking the electorate to do, that's the voters, that, the electorate means voters. When you're asking the voters, you got to figure out a way to put this into a, shall we amend the charter to say this? And it has to be definable. So when you're thinking about changes to the charter, you have to also think about how you're going to word that in a positive for the voters to vote for or against it. Because if you got all these 10 different things, it's going to be, you're going to be challenged getting that down for the voters. So think about how you can define it. Maybe the ordinance is the way to go, and it'd give the people a chance to vote, to
Yeah.
weigh in on that.
Sherry, I saw your hand up.
Thank you.
Oh.
I just wanted to go back and, with what Larry had said earlier, that
again, we're kind of circling here, but the eligibility, this defines itself. And the definition of elector is a person that has the right to vote. That is the definition of elector. So if it's saying that it's a qualified elector, then they are qualified to vote, they have not had their civil rights removed. And we, in all this that's been discussed, we have to be very careful because unless a person's civil rights have been removed, they have their rights. They have the right to vote. They have the right to run for office. So, you know, it's not like they're not applying for a government job. They're running for office. And we don't have the rights to do that. So I think that we're trying to fix something here that may not be broke. If the city itself defines later on or decides later on that there's things that they need to do, then that's something on their part, but not on the charter is where I'm standing with this.
Okay, I'm going to take one more comment from anybody, and then we'll move on.
Why don't we just take a vote on whether we want to leave it like it is or whether we want to address a change? And then we could list the changes specifically. But if we don't get enough votes to change it, what's the point?
I did have one question. What is the
Speak up,
what
please.
is the time frame between you talk about doing an ordinance or a resolution compared to putting this in the charter? I mean, is it that if you talk about something that can be resolved with an ordinance or a
Well, the
resolution?
difference would, yeah, if it's, and correct me if I'm wrong, guys, but an ordinance or a resolution would be the city council. If it's in the charter, that has to be
Done with
approved by
us.
the voters.
Right,
Not just us, but by the voters.
right.
So I think that the city council there's only 5 of them as opposed to 25,000 voters.
I'd like Sherry or somebody to.
Yeah, I can't,
I'd like to hear those 3 specific part of the definition, now just to refresh me, the definition of what an elector is, because it is defined like Sherry said. So they haven't had their civil rights removed. They have,
If they haven't had their civil rights removed, they're allowed to run for office. If they are convicted of a felony and their civil rights are removed as one of the consequences of that felony, depending on the level, then they have to go back or appeal that and try to come up to get their voting rights again.
Okay.
But if they have the right to vote, which is a qualified elector,
right?
and their rights have not been removed, then they are qualified to run for an office. And that's at any level. So at a city government level, at a city level, for us to try to remove that or to have a stronger stipulation, I understand we're trying to prevent past history, but moving forward, we have educated the citizens of Sebastian and to pay more attention. So, in trying to define parameters in order to prevent something, again, I think we're overstepping our boundaries on this. And I think that we need to just, if it's defined as a qualified elector, that is the definition of it itself. It defines itself. So again, I don't think the sentence is broken.
all right, so what I'm going to do now is I'm simply going to ask for a hand vote to follow your suggestion, Larry. How many of you believe that we need to modify this section of the charter? Raise your hand. Nobody wants to modify this now?
This is a vote to change, right?
Yes. After all of the suggestions, nobody wants? Go ahead, yeah.
Now knowing that you can do many of these things by ordinance or resolution or those types of things, I'm inclined to agree with Larry that we can leave this the way it is, and then leave it to individuals to talk to their city councilman and see if they have any interest in doing any other things.
All right. Okay, so then we'll move on. That was a great discussion, guys. We are now on to section 203, election. And there's an A and B. We'll take them all at once. Mr. Napier.
I'd like to see us consider changing the terms for city council from 2 years to 4. So you don't have to have an election every year. It's been thought of before. I was on this committee back in the very early 90s when they first did it, and we made that recommendation to the city council. Of course, they didn't take our advice. They didn't change it. They left it alone. But I would like to see us look at making it 4-year terms.
And we actually did that last time around, and again, it did not make it past city council.
That's the tough sell to get it by city council.
Yeah, well, I don't think that should preclude us from moving it forward if this is what the committee wants to do. Vicki?
I'd be interested if, I'm not adverse to a 4-year term, if in conjunction with that, there was a term limitation.
John?
Just a word of caution, as we just went through this last year, as everyone's aware, you have to wait until an individual has served 25% of their term before any recall can be brought forward. So if we were to change this to 4 years, we would be waiting a year instead of 6 months. Just FYI.
Anybody else? Okay, not seeing a lot of support here, Louise.
I would just like to say that this doesn't have the proverbial snowball's chance in you-know-where. Having been down this road numerous times, and as far as term limitations are, we have term limitations. It's
called elections.
It happens every single year. We limit you to you're done. So, I just think that, again, it has to be, it'll have to be, the council would have to vote to put it on the ballot. It won't happen.
Larry?
Well, it's not our job to try to figure out what the council will do. It's our job to make recommendations to change this charter and make it better. And if 4-year terms would make it better, then that's what this committee needs to recommend. And it's entirely up to the city council whether they yes or no it. It's what they do has no bearing on how we handle what we do.
Right. Amber, did you?
I'd also just like to remind everybody, I know this past year was hard and everything that happened was just a whirlwind, but that's the first time that's happened in the history of Sebastian. So I don't want to rearrange the charter around the debacle of last year. So that's just my personal opinion. Thank you.
And I would just add, I think the citizens would be very engaged to stay, we don't want to take a chance of people falling asleep over a 4-year period. I think it draws the citizens out when they know they have to vote, they have to get involved and stay engaged. It's just my 2 cents.
Anybody else? No? All right, so let's see a show of hands on who is interested in changing the terms from 2 years to 4 years. 1, 2, 3, 4, 5. Well, it doesn't look likely. Michael, I'm sorry, I don't mean to forget you. Is Mike participating? Okay.
He has not said anything, he's there.
Okay.
No, it's fine the way it is.
All right, then I guess we will not move that forward. We're on to section 204, term commencement. Does anybody have any ideas about term commencement? Okay. All right, let's talk about compensation, section 205. Anybody have any comments or input on 205 compensation? Mr. Napier?
Didn't they just recently change this?
No, this has not been changed since 2000.
I think it's adequate myself. I don't think it needs to be increased But they still get an expense stipend, do they not?
Yes.
It's not in this?
Yes.
Don't the council members get an expense stipend?
Mr. Carlisle?
Yes, they do.
All right, no strong feelings on that subject. Okay. Section 206. The mayor, there's a number of sections, so we'll go by paragraphs. Paragraph A is the mayor, the selection and term. And I do have some notes here from our city attorney. So before I share those, do I have input from anybody on the mayor?
I did. When I was reading the terms and stuff for everybody, I noticed under the vice mayor, it has that the term will be for 2 years unless removed or leaves or whatever. But for the mayor, there is no term, but the mayor is elected every 2 years. Every time the new council meets,
Every year.
the mayor is elected again.
Every year, council meets every year.
Is it every year?
They have an organizational meeting every year because they have an election. There's 2 one year, 3 the next.
Oh, okay, every year. But it doesn't say that the mayor's term would be for 1 year as well. There's no indication at all of what his term is.
Well, it does.
Well, I mean, as soon as the newly elected comes in there, but it says the same thing for the vice mayor, and it says his term will be for 1 year.
Yeah, but it says under mayor, as the first order of business, that means each time they have this organizational meeting, they elect the mayor from among its members. That tells you it's a 1 year term.
Yep. Okay.
Now, they may be reelected.
The reason I brought it up was because under the vice mayor, it says the same thing, the same wording, but then it also says the term of the vice mayor shall be for 1 year or until his successor is elected. So I didn't know if that needed to also be in there. I mean, it's fine the way it's written. I would just happen to notice those 2 differences.
Bruce?
Yeah, if I remember correctly, we had a thorough discussion of this 5 years ago, and the same discussion, same point was brought up, and we decided to leave it alone. That exactly what you're saying is that every year there's a reorganizational meeting and the mayor comes up, and somehow they wrote into the original one for the vice mayor 1 year, and they didn't do it, and it was like, okay, no need to change it. It just
that's fine.
the elections happen every year, so, yeah. So we just left it alone.
Anybody else have any input on that?
I'm good.
Okay. All right, anything else in the mayor section? If not, I will share with you,
Good.
under
Excuse
B.
me.
Yep.
Good. Comment, just a question. And it has, under the mayor's duties, it says in the middle of that paragraph, B, shall be recognized by the governor as the head of the city government for purposes of military law. Now, we've been in this emergency status, and that seems to have created some issues about who has authority when you're in an emergency. And obviously, an emergency is different than under military law. Is there somewhere we need to consider adding reference to?
Yes, I have, the suggestion which came from city staff speaks directly to what you just raised, and the suggestion is,
I defer to you then.
it says, "The mayor shall have the power to preserve the peace and order," and the suggestion is to insert in there, "The mayor shall have the power to declare a state of local emergency, comma, preserve the peace and order." How does everybody feel about that?
What's the rationale behind that request?
There's no rush.
All right, my
No, I said the
understanding,
rationale.
oh, I'm sorry, Vicki. I thought you were done.
I didn't hear the answer to the question.
My understanding with the state of emergency is that's got to be declared by a supermajority of council. Isn't that correct? And already worded?
Oh,
And then the
don't know.
duties fall to the city manager during that period? Am I hitting the nail over there, Paul, or?
No, through the chair, no, the mayor does have the authority to declare a state of a local emergency.
the mayor does have the authority now?
Yes.
The mayor currently does have the authority. It's not in the charter, it is in our code, but it does have the authority to declare a state of local emergency.
Mr. Carlisle?
Yeah, so the ordinance does authorize it, but it refers back to this section of the charter. So the reason that we thought it'd be beneficial to put that statement in this charter was because the emergency ordinance that allows the mayor to sign the ordinance refers back to 2.06. So if the duties were in the charter, it would make the ordinance consistent at the look back at the duties and responsibilities of the mayor. That was the only reason, if that makes sense.
Does that make sense to everybody?
Yes, it does.
All right,
Can I just ask what that ordinance is?
If I recall
I didn't
correctly.
hear the question.
What it-
Patty, what is the question?
you're saying that he does have the ability to declare that right now? I'd like to, is there a specific?
What Mr. Carlisle said was that it is in an ordinance,
Okay. May I
but
ask
it's
the
not
num-
in the charter.
Okay, may I ask the ordinance number?
It's 2.37 if I recall correctly.
2.37.
And so, Madam Chair, if I may clarify again, ordinance 2.37 says the mayor has the authority pursuant to charter subsection 2.06. The 2.06 doesn't specifically say the mayor has the right to declare the emergency. So you could get in this, you could have the potential to get in this round robin of, well, the charter doesn't say it, but the ordinance says you can't do it by the charter because the charter says that. So if we don't clarify it, we could get in this circle of logic of defining what the keeping the peace is in the charter.
So my question with that would be, is that in conjunction with a statewide, or can they do that on their own?
This
without-
is specifically, the suggestion is declare a state of local emergency.
Okay, so that would not be in conjunction with a national?
It
or-
could be,
But it doesn't have to?
right.
Okay. What kind of situations would require that, such as like a hurricane type of?
Right. Yeah, I guess.
So it could be a riot, it could be a local train spill of a hazardous chemical
Okay.
that creates
Okay.
specifically just a local state, not even countywide.
Sure,
That-
okay,
And those are drastics, but those are just instances that come to mind.
sure, okay.
Okay. So do we have we added this to our list?
The mayor shall have the power to declare states of local emergency.
All right, do I need to see a raise of hands on that? Everybody agree with that? Yes? Okay. All right. Though, that's the only thing I had under duties for the mayor. Anybody have any other duties for the mayor issues in B? Okay. Move on to the vice mayor. Selection and term. Does anybody have any input on the vice mayor? Shari?
I think on this one, then when we were, a few
Sherry, I
minutes ago-
can't hear you. Could
A
you?
few minutes ago, when we were discussing, or there was discussion about the difference in verbiage between A and C. If you, the last sentence of C, the vice mayor shall be elected using the same procedures as the election, as for the election of mayor, kind of says it all. So if you take the sentence, the whole sentence, the term of the vice mayor shall be for 1 year or until his or her successor is elected, out, you're still saying the same thing, because the mayor, and it says right here that the vice mayor is elected to the same procedure as the mayor.
So are you suggesting that we would eliminate that sentence?
Just, if you take out the term, all you're doing is saying the same thing. The first sentence says the same thing as the second sentence, as the last. On the last two sentences, they say the same thing. You're not changing the procedure. You're just taking out that 1 year, because it says that the vice mayor shall be elected using the same procedure as for the election of mayor. It's the same thing. And that the mayor is elected every new seating council, at the beginning of every new seating, it's every year that he'll be elected. And the vice mayor will do the same thing. It's the same procedure.
So what is your suggestion?
My suggestion would be to remove the sentence that says the term of the vice mayor shall be for 1 year or until his or her successor is elected.
Okay, anybody
Because
have any?
if you're doing it, if they're saying that it's done the same way as the mayor, it says in the mayor when they'll be done, how it's done.
Anybody have any comments about that? Do we like that suggestion? Is that something we want to put on the list? Vicki?
I think it's reasonable for cleanup purposes. If you're trying to get all of the pieces of the puzzle to be congruent, it's superfluous. I mean, you're exactly right. It doesn't need to be there.
Okay. Any other comments on that item?
I agree.
You agree? Okay. All right, so let's just see a show of hands. We want to eliminate that sentence. The term of the vice mayor shall be for 1 year or until his or her successor is elected. Everybody agrees. Almost everybody agrees. Okay, you got that one? Okay, thank you. And under vice mayor duties in general, any other comments? Seeing none, we will go to section E, vacancies.
We're at 07, right?
Do you have any comments on vacancies? Go ahead.
And I don't know if we can do this or not, but one of the things that there's been a lot of discussion on throughout the course of, I think, a lot of the citizens, is that it allows in here for someone that's convicted of a crime to be removed from office. And I understand that this is an elected position, and I don't know if legally this is possible, but it seems like if someone is charged with a crime that is directly related to their position here for the city, that there should be a way to suspend them from their position until that crime is resolved. Not remove them, I mean, if you want to still pay them, whatever, but remove them from their position and their decision-making abilities until that is resolved. I don't know.
Have we skipped down to, are we at?
Go ahead,
two?
Larry.
Isn't that the governor's job?
Vacancies?
The governor's the one that determines when an elected official may be suspended or removed from office. And I think you're going to get on shaky grounds if you try to remove someone that's elected just because they've been charged with something. Just because you get indicted does not mean you are guilty.
No, and I'm sorry, should I?
No, go ahead.
I understand that, and that's why I said, if it's something specifically related to, the city, like they're charged with, and get away from last summer, they charged you with embezzling $100,000 out of the city funds, okay? So we're gonna leave them in a position where they can make that $200,000 or $300,000. I mean, I'm not saying they're investigated, I'm not saying they're rumors, I'm saying they are charged with a criminal offense, okay? And when it gets to that point, maybe they should have to step away, and not everybody.
Guilty.
True.
If you're not adjudicated guilty, you're still innocent.
Yeah, so that's why I'm saying they could stay in their, not stay in their position, but they're not removed, they're just suspended. Any other anything has that. Any other profession, and I understand that they're elected, but I don't know. Okay,
Madam
I'm
Chair,
done.
point of order.
Certainly.
All these issues can be addressed later on in 2.08. I assume we're still on
That's where we are.
2.06E? But
we're
the
on-
issues that she's referring to, I guess, will be addressed later on 2.08, which talks about vacancies, forfeitures of office, and filling of
That's
vacancies.
where we are, Manny. We're on
We
vacancies.
moved there already?
Yeah, I
thought
think
that's
you
where
jumped
we were.
right.
206E.
Where's 7?
Oh, I'm sorry. You're right.
I went down to the other one, too.
Okay. All right, I did it too.
Okay, so we're on 206E.
We weren't finished with E when she was.
Yeah. Okay. Any comments on E? And my apologies, I did the same thing you did, Sharon.
Sorry.
It's okay. All right, we'll move on now to section 207, general powers and duties. And now, we will go to section A, vacancies. Now we're where we need to be. And I will tell you that I do have several suggestions here. The first one in paragraph A is to include the word suspension. This is not really clear to me, Mr. Anand, maybe you can help on 208A. I'm not worried about the capitalizations, but the word suspension is in red.
I'm sure, are you reading the, what the staff was recommending?
Mm-hmm.
Okay. What staff recommended was to add several sections to 2.08.
If we could just stay on A for the time being.
A was just, yes, the word suspension, forfeiture and suspensions.
So that there should be authorized by law or forfeiture and/or suspension of his or her office? Is that what the suggestion is?
That was a suggestion, Madam Chair, to add
Okay.
the word suspension.
All right. How do we feel about that?
Is there a process? I mean, is there presently a
I
suspension
think we're going to cover the
process?
process part of it as we get further on down in terms of suspension. That's included in some notes that I have here. It's a valid question. How do you get suspended? So maybe what we should do is just leave 208A for the time being, anticipating that we're going to discuss suspension. Does that make sense to everybody? I see hands. Go ahead.
Does remove from office in any manner authorized mean suspension?
It says the office shall become vacant based on certain things.
Right, and if you read the second sentence under A, after the comma, it says removal from office in any manner authorized. Would that not include suspension? And we're
Yes.
playing with words a lot throughout this change. And I don't know, to me, it
Suspended, you
seems
can't
like it's...
act.
Okay.
Well, I guess the question is, who made that idea and what were they thinking?
This is a recommendation that came from staff. And then there are additional comments about suspension further down. So what I'd like to do is get through that discussion and then we can go back. All right? And let me just share with you what I have in front of me because it's quite detailed. Under section A and B, there's only some minor capitalizations, but there is a proposed paragraph C, suspension from office, and I will read it to you. A council member or the mayor shall be suspended from his/her office if he or she is arrested for a felony or for a misdemeanor related to the duties of office or for a sunshine law violation. That would be how you get suspended.
Madam Chair, that's new language.
I'm sorry?
This is new language?
This is new language.
Okay.
Do you want me to read it again?
Nope, I've got it.
You got it? How does everybody feel about that?
Can I add something, Madam Chair?
Yeah, sure.
The main purpose, I guess, behind staff's recommendation is when you look at the forfeiture of office, it just gives four things and no teeth. It just gives forfeiture office, okay, well, and what can we do? You can't get rid of them, they're still in office, you gotta still rely either on the governor or whatever, which is what we tried to do in the past. So what we were trying to do here is to add a subsection C and add a subsection D. The subsection C, Chair already read, which is a suspension from office and when you can suspend someone. Again, this is just recommendation. And subsection D is specifically how you do it, is by having a special hearing. And then, and she could read that later on, but that's what C and D is. And pretty much that's it. Later on, there's other suggestions, but that's the purpose behind what we were trying to do. Is the question that came to me is, what does 2.08 B Bravo do? You know, pretty much nothing. I mean, it just, they can forfeit office, you know, for those four reasons, and then what? You can't get rid of them unless the governor steps in and does what he has to do. But, yes, you want to add?
No, I do want to add, because it says if you miss 3 council meetings unexcused, you're removed from office.
Right.
Who removes you? So the governor's not going to remove you for missing 3 meetings. So if you're going to have this in the charter, you have to have a methodology to enforce it, or you have to remove it, because there's no sense in having a law if you're not going to have the ability to enforce it and how you enforce it. So I understand you're not guilty of a crime, but if you miss 3 meetings, you're out of office. But who escorts you out the door? So that's why the charter is kind of vague in how you enforce these provisions of the charter. If I violate the charter, how do I get removed from office? By the council, or do I have to take you to court? How do you get removed from office? Because that's what the charter says happens.
Okay. I think that what I would like to do, hang on guys, I feel like we're at a disadvantage because I have documents in front of me that you don't have, and you haven't had time to really think about it. So what I'd like to do is put this on the list, and maybe at our next meeting, we will distribute this to everybody, and then at the next meeting, take this because it is complicated in terms of the suspension and the hearings and that kind of thing. And while I have it in front of me and I can read it to you, I would just be more comfortable if you had some time to digest this whole section. Yes, ma'am.
So would that be distributed, shortly after this meeting in the next few days so that we can have it available?
I would ask the city
And then-
clerk to send it to you after
Okay,
our
great.
meeting, and then at our next meeting, we can circle back to this item.
And then secondly, the list that we're creating, can we also have a copy of that as well?
Larry, go ahead.
Doesn't the council have authority now to remove a sitting council member for cause?
Mr. Attorney, somebody?
Based on what, for cause? Where does it say that?
Is that a yes or no?
Doesn't.
No. The only thing, right now, all we have is in section 2.8 are those four things you're listing right there. Lack at any time during him or her office qualification or whatever, violation of the express prohibition of this charter, convicted of a crime involving moral turpitude, or the not coming to meeting 3 times.
These are the causes.
That's it. And
the
how do you
suggestion,
remove, I think you're the one that made that point, these are elected officials. Based on what? It doesn't say here, how do we remove them? It just says, these are the causes, and then what? Like, when it came to me, it was, this is written that way, but there's no teeth to it, that you can't do anything, and I agree. So the only thing we had left was remedy at that point in time was the governor. And he refused.
John?
I've got a concern. I know it's before your time, Manny, but years ago, we had 2 council members that were charged with violating the Sunshine Law simply for talking about lawn bowling on the tennis courts. That was Andrea Coy and Sal Neglia, many years back. You know, that was certainly not, it's a violation of the Sunshine Law. That was a charge. They were found innocent, but it took 9 months. So we got to be careful where we go with this here. And we really got to think this out. I agree we're trying to achieve a goal here, but say Louise and I were to speak of something that was very casual, could we be removed? You know, say we sat on city council 10 years from now. You'll be around in 10 years, Louise.
All right, again, I'd like to move on from this topic.
Madam Chair, I do have a, I know that you do want to move on, I'm sorry to interrupt, but I would like some clarification if we're going to have this as a study to bring back, because I believe when you read it, that you said that it was related to misdemeanor felony in violation of Sunshine Law, and I'd like to know if, on the Sunshine Law, if it's a civil infraction, again, because like what John just said, you know, you have a civil infraction, are we removing somebody or suspending somebody because they talked about lawn blowing or lawn mowing, or because it's a misdemeanor? If it's a misdemeanor, then you've already covered it with misdemeanor. So I'd like some clarification on that before we're giving this to review for next time.
All right. Okay, so I will make sure that you all receive a copy of the suggested changes for section 208, and we will make that our first item on the agenda at our next meeting. Okay? Everybody good with that?
Yeah. Madam Chair, if I can?
Yep.
I think then by the same token, I would suggest then you provide them the city's suggestion for 212. Because that also has several comments.
I would agree with that, but we haven't got there yet, but I'll do that. All right, if everybody is good with that, that moves us to section 209, and I don't know about the rest of you, but I would like a 5-minute break. Okay? Adjourned. go ahead and bring this meeting back to order, and we are now on section 209. And our marching orders for tonight was to get through section 2 completely.
Yeah, Madam Chair, if I can?
I got you covered.
No, I think Ms. Matthew had a question, and I just want to make sure we put it on the record what her question was.
All right, well,
Okay.
before I get to the
Okay.
question, in addition to comments from city staff on 208, there are also suggestions under section 2.12. And so I would also, again, have these sent out to you, and we will cover them at our second item on our agenda for the next meeting. Okay, now, Ms. Matthews, do you have a question?
It was more of a statement on the information that we're being given, especially that pertains to.
I can't hear you, yeah.
Sorry. It was more of a statement that on section 2.08, is that, so we are on the paraphernalia that we're getting to study for next meeting, is to make sure on the clarification of the statement that you read was said related to office resulting in misdemeanor, felony, or violation of sunshine law. And I need clarification on that, because the state attorney, who's going to bring it in, misdemeanor, sunshine law can be a misdemeanor, which is a criminal or a civil. So
Right.
I'm just wanting clarification in that of what they're looking for and where they're going as to why they've included a civil case for suspension.
Is that a question for you, Mr. Anand?
Well, I mean, I don't think the intent was to do a civil infraction. Civil infraction, how we understand from the state attorney's office, is it all depends on intent. If they can prove the intent, they go criminally. If they cannot, then they'll do a fine and they'll resolve it civilly. So I guess we'll just wait till you read it, and then you can make suggestions when you guys come back next time. But the intent is for the misdemeanor criminal, not the civil infraction.
Thank you, sir. And I guess my reasoning for that is because you've listed misdemeanor and then sunshine, so separately, was my clarification for that. Thank you.
Okay. All right, and again, we're going to take section 212 for the next meeting as well, which leads us to section 2.09, Judge of Qualifications. Okay,
I think that's fine the way it's written.
okay. All right, anybody else have any other comments?
I guess I don't think it's a very big deal, but it's curious to me that this seems to supersede any qualifications that we might require if the state has the right to, the Florida Division of Elections can override? Is that what I'm reading? Can't believe I didn't read that before.
I know the Department of Elections, Supervisor of Election has their own set of rules, and which we have to comply with. But again, I'm not sure the specific question. But again, when it comes to qualification, I'll have to defer to the city clerk on this. But I do know that the the Supervisor of Election has her own rules that we have to comply with.
That raises a question for you, from me. If we create a qualification that is different or in conflict with the Division of Elections, what would happen?
We shouldn't be doing that. It should be nested in that. But again, I'm talking out of my lane. Supervisor of Election has her own set parameters. We can have our own qualifications as to what our elector wants to, what the qualification would be, whether it is 1 year, living here for 1 year, whether it requires them to actually physically live here for 1 year. Those are up to the board to decide what we want to determine locally, what those requirements are.
Okay. Jeanette, do you have anything to add to that?
I wonder what the legislative intent was back in the 1988s on that, because I kind of see where Ms. Cottenberg is, what she means. I understand what she's saying, so let me go back and look at the minutes and see if I can see anything in the minutes from the 80s.
Okay. Okay. Sherry?
I think this is in regards to things that, of a candidate who is elected in, and there may be something that comes about. I can give an example of something that has come about in the last few years up here, and that's a candidate, it's on a candidate being in, having dual oaths of office, that type of thing. And this is where what happens is that the person is voted in, the candidate has already met the city's qualifications, they've run, the candidate comes in, then the elections comes in and they oversee it, they go in and they validate, they qualify, and if there's nothing, if there aren't any other qualifiers that take them out of it, then this is where they would go ahead and qualify you as well and say that you're in office. But some of those things do get past the city level governments, even the county governments, that there are things that you cannot do at the state level of elections. So, and I think that's where this is in play. I personally don't see anything wrong with this. I think it keeps us covered for things that may slip through the crack.
If I can, Madam Chair.
Yep.
After reading it again really carefully, yeah, those are three different departments, the Florida Department of Elections, the Ethics Department, and courts determines issue relating to elections and qualifications, specifically forfeitures, and what we went through, which is the recall as well. Courts determine those issues.
Okay. If everybody's good with section 209, we'll move on to section 210. This is City Council Employee Relationships. Have any comments or questions from anybody on this item? Any changes? No, seeing none. We'll move on to section 211, investigations. I don't see any raised hands, any comments. Is everybody good with that? Okay. Section 212 is procedure. That's the one that we are going to get to next meeting. Section 212.13, emergency ordinances. I do have, well, these are just capitalization of lettered words, so I'm going to be too concerned about them. Emergency ordinances. Do I have any feedback, any input on emergency ordinances? No? Seeing none? Section 2.15. I'm sorry, section 2.14, Codes of Technical Regulations. Any comments or questions on that one? No? All right, we'll move on to section 2.15, authentication and recording, codification and printing. Oh, come on. Nobody has any comments or questions on that one, huh? It's pretty dry stuff. All right, section 2.16, standing committees. Again, no comments, no questions?
I think it's fine.
Everything's fine. Okay. 2.16, I think that takes us to the end of our agenda today. Could I ask you to put our list up on whoever has the list? This is our work product for tonight. And if we could include that in the transmittal to committee members so they can have it in their package. Any staff matters? Jeanette, any staff matters from you? No? Mr. Don? Mr. Carlisle? Thank you guys very much. Thank you all for giving us your input. It does help. Committee member matters. Anybody have anything they want?
Do we have a date for next month?
I believe we do. Jeanette, do you know what the date is? Yeah, we have a schedule out.
We adopted.
Oh, I'm sorry. Thank you, Patty. February is what we're looking at. Jeanette, I'm gonna defer to you on this in terms of setting the date for the meeting.
Okay. You want me to reach out to the members tomorrow?
Yeah,
Okay. All right.
yeah. And then she can notify.
Madam Chair, I think they're going to need to vote on that date so the public can be noticed, but I'll leave it to you all to decide.
We need to vote on the date?
You did it the last meeting, I'm just saying. I yield to the...
Grace?
My question is, are we doing another meeting in January to continue this and then starting with the next two sections in February, or?
That's up to the board.
That's up to us. I mean, we could come back and, well, it's kind of pushing.
Well, I know we held some things
Yeah, we
because
have
you're
two
going
on-
to
you're
email
right.
us the
What I'd like to
information,
suggest is we try
and I
and
didn't know if
schedule
we
it
were gonna-
earlier in February, and then that way we can have some cushion if we need to add another meeting. I understand what you're saying.
Right. So I didn't know if we needed to discuss having another one in a couple of weeks, or if we could wait, if you wanted to wait until maybe the first week in February, finish this,
Yeah.
and then do one more meeting in February for Articles 3 and 4.
Yeah.
So,
Yeah.
I don't know if
Well,
you're suggesting or...
Grace, what I'd like Jeanette to do is do an email to all of you with maybe 2 dates as early as possible in February. And that way, I see lots of comments here.
Madam Chair, if I
More
can.
comments on scheduling the meeting. Go ahead.
We kind of already have that right now,
You have what?
the 8th or the 9th or the 11th or the 23rd or the 25th.
Those were proposed dates.
Right, I mean, we have them now where we can set them.
I'm gone the week of the 8th.
Sherry, go ahead.
I'm trying, just to make this a little bit easier, if you look at the schedule that was given at the first meeting, in the month of April, those meeting dates that are there, those are to revisit all the recommendations of articles. So instead of trying to rush through something, if we just continue on the path that we're taking and go through the schedule, then we have the month of April to go back to some of these things.
Yeah, I'm going to let Jeanette get the next date scheduled. And part of the reason why I'm doing that is because there are other things that are scheduled here at City Council as well, or in these chambers. So,
Madam Chair, if I can, I think what the clerk is doing now, these dates that we have already been vetted, that there's nothing, they're available dates. So,
okay,
if we can go ahead and pick one,
that's
and
a
we're all
great
here, that'd be
suggestion.
great.
Thank you.
Thank you.
Let's do that. Let me see a show of hands for all who are available for February 8th. Everybody available? Okay, the majority of us are available. Then our next meeting will be February 8th.
Thank you.
That made that much easier. Thank you.
All right,
This is who we voted on?
Tuesday looks like
I'm sorry, I didn't see it all right.
Madam Chair?
Your homework will be Article 3 and 4. We will also be starting with those two sections in 2.
So that's a Monday, I believe.
It looks like the
Can you do
9th
that?
is
You have a share, a hand share.
Beth, I have a
Henry.
I can't hear.
February 8th isn't highlighted on the calendar.
Yeah, it looks like the 9th.
Madam Chair, I think the Budget Committee
which
took
is a Wednesday,
February
meeting
8th.
on Tuesdays.
I apologize.
All right, anybody, is everybody available for February 9th?
Well, Madam Chair, are we sure that that doesn't conflict with any other city meetings?
That's what Jeanette just handed out to us.
All right, because we're seeing what's filled in. City council meets on Wednesdays and P and Z is on
No,
Thursday.
February
I don't know
9th
about
is
the
a
parks.
Tuesday, John.
Okay. 9th is fine with me.
Okay. Is it? That's what I just said.
Sunday, Monday, Tuesday, okay. Looking at this.
All right, February 9th it is, right? And it is section 3 and 4, but we will be starting with section 2. Right, 208 and 215.
Beth, is it possible to add the other date? in
Not
February?
right now, no. I think that we need to keep it flexible because of how much progress we make, and to Grace's point, that we may either get it done quickly or we may need an extra meeting. Any other committee members? Matters. You all matter. All right, then I will adjourn the meeting. Thank you, guys.